Most people think if they own a house together and one of them dies, the other one automatically gets it and voids probate. A lot of the time, that is not true. Hi, I'm Toby Mathis. I've been a practicing attorney for close to 30 years. The reason so many people get caught off guard and have a nightmare experience in the courts comes down to two words that were missing from the deed. And let's use an example. Bill and Sally are married. They own a house together. They assume everything is fine. They assume if Bill dies first, Sally automatically owns the whole house and life moves on. Then Bill dies. Now Sally is sitting in a probate attorney's office finding out that part of the house is going to go through the probate process because that deed was missing two very important words: joint tenants. Those two words matter a lot because when you own property as joint tenants with right of survivorship, the surviving owner automatically gets the property when the other owner dies. No probate of that asset, no court, just to figure out who owns the house. You just get it. But if those words are not on the deed, the law in many cases treats Bill and Sally as tenants in common instead. And that is a completely different result. Bill and Sally thought they owned the house together, so they would pass automatically, but the deed language did not actually give them survivorship. Tenants in common means each person owns a share separately. So if Bill owned half and Sally owned half, Bill's half does not automatically go to Sally when he dies. Bill's half goes according to his estate plan. And if all he had was a will, that usually means probate. So now Sally owns her half and Bill's half is stuck in court. And that is how families end up in probate by accident. They thought they had the simple version. They thought they had survivorship. They thought the house would pass automatically, but the deed did not say what it needed to say. Now, it depends on your state because some states are community property states, some are separate property states, and there's different language. But there is almost always specific language that is required on a deed to create that survivorship. Miss those words, and you have a mess. And this gets even uglier if there are kids from a prior marriage, if there's family conflict, if there's creditor issues, or anybody who thinks they're entitled to that piece of property and they come out of the woodwork. Now, instead of a clean transfer, you have delay, expense, and a legal mess around the family home. This is one of the reasons I tell people, do not do your own deeds. Real estate deeds look simple until they're not. And the problem is you usually don't discover the mistake when you sign it. It's later. You discover it when somebody dies, and then it's too late. And let me say this too. Even better than relying on those two words is to own your house in trust. A living trust is often a better option because it's not just deal with what happens when you die, it can also deal with what happens when you become incapacitated. It gives you more control, more flexibility, and it keeps the property out of probate if it's titled in the trust. And in some cases, we just use a residence trust, like a land trust. And it's just like a living trust, but it can also help with things like privacy, it can simplify transfers, and it adds another layer of planning around how the property is held. So yes, if you're going to own the property jointly and you want survivorship, those two words matter: joint tenants. But the better question is not just, did you use the right words? The better question is, why are you relying on that at all when you could own the property in a trust and do this the right way? Because good planning is not about avoiding one probate trap. It's about making sure your home is handled in the way you want it during your life, at death, and everything in between. So if you own a house with a spouse, a child, or anyone else, pull out that deed and make sure you know exactly how it's held. Because Bill and Sally thought they were fine until probate proved otherwise.